I'm about to go to bed after a very long day, but I saw this question. I had to answer it tonight because jurors are not allowed to go home and print public transcripts and read them. That is absolutely out of the question. And if they did that, it would completely invalidate everything that's been done so far. I'm Eliza Orland's career public defender here in Manhattan for the last 14, almost 15 years. And now I'm going to read you some of the required jury admonitions that Judge Mershon read to the jury, or something very similar. This is from the CJI jury instructions at the start of the Trump trial. And these admonitions are required, and the law requires that jurors follow these instructions in order to help assure a just and fair trial. 1, do not converse either among yourselves or with anyone else about anything related to the case. You may tell the people with whom you live and your employer that you are a juror and give them information about when you will be required to be in court, but you may not talk with them or anyone else about anything related to the case. 2, do not at any time during the trial request, accept, agree to accept, or discuss with any person the receipt or acceptance of any payment or benefit in return for supplying any information concerning the trial. You must promptly, this is number 3, you must promptly report directly to me any incident within your knowledge involving an attempt by any person improperly to influence you or a member of the jury. 4, do not visit or view the premises or place where the charged crime was allegedly committed, or any other premises or place involved in the case, and you must not use internet maps or Google Earth or any other program or device to search for and view any location discussed in the testimony. 5, do not read, view, or listen to any accounts or discussions of the case reported by newspapers, television, radio, the internet, or any other news media. 6, do not attempt to research any fact, issue, or law related to this case, whether by discussion with others, by research in a library or on the internet, or by any other means or source. In this age of instant electronic communication and research, I want to emphasize that in addition to not conversing face-to-face with anyone about the case, you must not communicate with anyone about the case by any other means, including telephone, text message, email, internet chat, or chat rooms, blogs, social websites such as Facebook or Twitter. You must not provide any information about the case to anyone by any means whatsoever, and that includes the posting of information about the case or what you are doing in the case or on any device or internet site, including blogs, chat rooms, social websites, or any other means. You also must not Google or otherwise search for any information about the case or law which applies to the case or the people involved in the case, including the defendant, the witnesses, the lawyers, or the judge. Now, ladies and gentlemen, I want you to understand why these rules are so important. Our law does not permit jurors to converse with anyone else about the case or permit anyone to talk to them about the case because only jurors are authorized to render a verdict. Only you have been found to be fair, and only you have promised to be fair. No one else has been so qualified. Our law also does not permit jurors to converse among themselves about the case until the court tells them to begin deliberations, because premature discussions can lead to a premature final decision. Our law does not permit you to visit the place discussed in testimony. You can't be sure the place is in the same condition, even if it were. Once you go there to evaluate evidence in light of what you see, you may become a witness, not a juror, and have an erroneous view of the scene that may not be subject to correction by either party. That is not fair. Finally, our law requires that you not read or listen to any news accounts of the case, and that you not attempt to research any fact, issue, or law related to the case. Your decision must be based solely on the testimony and other evidence presented in this courtroom. It would not be fair to the parties for you to base your decision on some reporter's view or opinion or upon information you acquire outside the courtroom. These rules are designed to help guarantee a fair trial. And our law accordingly sets forth serious consequences if the rules are not followed. I trust you understand and appreciate the importance of following these rules, and in accord with your oath and promise, I know you will do so. There are things in the transcript that is posted online that was deliberately done outside the presence of the jury. Every single sidebar that's recorded, so many other things. If the jurors were to log on and print out the transcripts that were public, they would see things that they were specifically not supposed to see, and it could impact their decision. So it would be hugely problematic. It would invalidate the jury. If the judge were to find out, he would probably have to call a mistrial, especially if that person had brought any of that stuff into deliberation. So no, the answer is no. Jurors cannot do any independent research. They can only ask for readback or ask for other evidence in a note to the judge, and then the judge and the lawyers determine what will be provided to the jurors, and that will happen, and that's what we're going to see tomorrow. Okay, that's it for tonight. I'm exhausted. Good night, everyone. Feel free to keep leaving me questions. I'll try not to, get sidetracked and have to make another video tonight. Good night.